State vs. Lynch. Chapter 1 The Gavel of Injustice Rings Hollow. This report unveils the deeply troubling case of State vs. Lynch, exposing a justice system in the Ninth Judicial Circuit, distorted by collusion and abuses of power. This case is not merely a legal battle. It's a stark indictment of a system where those entrusted with upholding justice prioritize self-preservation and expediency over fundamental rights. This chapter lays the groundwork, introducing the key players, charges against Ms. Lynch, and the initial red flags signaling a blatant disregard for due process and ethical conduct. The accusation and initial red flags. Kelli Lynch, a 45-year-old mother of 3 who has never been in any serious trouble, and no felony arrests, found herself ensnared in a web of serious charges. First-degree fraud charges and first-degree trafficking in prescription drugs. These allegations stem not from a life of crime, but from a desperate attempt to escape a cycle of domestic abuse. Seeking refuge with friends, Ms. Lynch soon discovered their involvement in illegal activities. However, their actions did not directly involve her, and she felt safer with them than returning to the clutches of her abuser. Under immense pressure and with assurances she would not face serious consequences, Ms. Lynch reluctantly agreed to participate in what she was led to believe was a minor, victimless act at a car dealership. She was given a fake ID and accompanied to the dealership, with the understanding that her role was minimal, simply presenting the ID. Unbeknownst to Ms. Lynch, the dealership grew suspicious and alerted the police. Before she became aware of the police presence, the gravity of the situation dawned on her, and she immediately attempted to back out. An argument erupted with her co-defendant, and Ms. Lynch made a clear effort to leave the dealership on her own, effectively abandoning any further participation in the alleged crime. Unfortunately, law enforcement apprehended her before she could fully extricate herself. This attempt to withdraw from the criminal activity, undertaken before she knew the police were involved, is a key factor in Ms. Lynch's defense. Legal principles like the abandonment defense recognize that individuals who voluntarily and completely renounce their criminal intent before the crime is completed, and without knowledge of impending law enforcement intervention, may not be held criminally liable. This is clearly stated in Section 777.045 of the Florida statutes. Creates a defense to an attempt offense if, under circumstances manifesting a complete and voluntary renunciation of his or her criminal purpose, the defendant abandoned his or her attempt to commit the offense. Ms. Lynch's actions, arguing with her co-defendant and physically attempting to leave, demonstrate a clear intent to abandon the enterprise. However, the subsequent legal proceedings, as detailed in this report, raise serious questions about whether the court fairly considered this defense or any mitigating circumstances. Failure to launch. The trafficking charge was rather an easy one. It was a full prescription unopened of her family member that she picked up earlier that day at the pharmacy. However, even though Mr. Mills was given the prescription and even had the family member come to court during her bond hearing, he failed to call the family member to show the court the prescription and have the charge dropped, which resulted in a $5,000 increase in bond. This should have been the first red flag with Mr. Mills' representation. Another red flag not knowing at the time is that he defended one of the co-defendants in the case, and did not receive approval from either defendant to sign a waiver. We should have asked for a refund then, being we still have not received any refund probably wouldn't have done any good. Early signs of trouble. A pattern of continuance and incompetence. Despite the complexities of the case and Ms. Lynch's potential defenses, her initial attorney, Jonathan Mills, exhibited a troubling lack of progress in preparing her defense. In fact, a review of the court file reveals that he failed to attend a single pretrial hearing, resulting in multiple continuances and delays. This disregard for his client's case mirrors the egregious misconduct detailed in the Florida Bar v. Williams, where attorney Patricia Williams was ultimately disbarred for a pattern of neglect and dishonesty that severely prejudiced her clients. Just as Williams' clients were left in legal limbo by her inaction, Ms. Lynch faced a similar fate due to Mr. Mills' negligence. The court transcripts from April 11, 2023, paint a stark picture of Mr. Mills' incompetence.
Page 69, State of Florida versus Kelli Lynch, 2022 CF 688 State.
Richard Walsh for the State of Florida.
Defense.
Michael Brown for the defendant stepping in for Mr. Mills, Your Honor.
All right, what are we doing on this one?
We're asking for a continuance, Judge.
Why?
The state opposes it. Mr. Mills told me he had depo set on March 29th. Subpoenas were non-served. The address on the witness list. He received one amended address yesterday, he tells me, and depos have been re-noticed for May 12th. He's also trying to set up a proffer and waiting on some info for his client. So ask for a continuance to see these depositions through.
All right, Mr. Walsh.
You are the only participant.
Yes, Your Honor. As counsel stated, the state objects. This case is 1.5 years old. Mr. Mills has been on the case since June of last year. This is the 7th time it is set for trial. The subpoenas have gone out. Witnesses are getting frustrated, and frankly, so am I. As far as the deposition...
Frankly, so am I. I'm going to give one final continuance over state objection. We're going to set it for trial May 18th. No more continuances for discovery.
Could I be heard more on that? Because I believe last time you may have indicated that there was a final continuance over the state's objection on March the 10th. We have expended a lot of time preparing. As far as the depots are concerned, 2 out of the 3 people are actually associates affiliated with the crime. They are listed as people who know something about the case, but they will not be called by the state. One of them was just arrested, I believe, last week or the week before on a totally unrelated charge. The likelihood of them appearing are slim. The likelihood of them not taking the Fifth Amendment are slim. The other one is an officer who's been available for deposition for a year and a half. The deposition was noticed without any coordination with my office. While I'm on vacation, we'll be out of the country.
Where are you going?
I'm going to Mediterranean.
Oh, nice.
So if we gave a final continuance in March, I'm just not sure what that means if we give a second final continuance. As I said, there's a level of frustration here.
The motion that was filed in March said you do not object. Is your recollection different that you did object at that time?
I have final continuance over state's objection when it was set for today. That's what my notes say.
The motion.
Bankowitz appeared for Mr. Mills. I believe he was in trial, but I'm not sure.
In Polk County, probably?
I don't recall.
Yes.
If my notes are wrong, I apologize. But
No. I'm just saying what the motion said. I don't know if that's what.
Judge, you need me to respond?
No, I did say final continuance last time.
I find the state's argument here that they listed a witness, but they listed him. The defense has the right to investigate that.
Yeah, but in March they told me they were deposing him.
And they came back non-served based on the addresses.
Seems like something that could have been done, I don't know, a year ago. I'm going to deny the continuance. We're going to set it for trial case management next Thursday.
Judge, can I ask, I'll probably have to have somebody cover for me because I think I may still be in trial next Thursday in another division.
That's fine.
But I could arrange for somebody to cover.
All right. So we'll set it at 9 a.m.?
What's the date?
4:20. TCM. Defendant appearance required cannot be waived.
This exchange lays bare the stark reality of Ms. Lynch's situation. Her attorney, who was paid $15,000 to defend her based off the abandonment defense, has failed to conduct any pretrial investigation and is now under scrutiny of the court. The parallels to the Florida Bar versus Williams are chilling. Justice Patricia Williams prioritized her own interests over her client's. Jonathan Mills' actions suggest a similar disregard for his client's well-being. Mr. Mills's incompetence threatened to collapse entirely under the weight of a system more concerned with appearances than with ensuring a fair trial for a woman desperately in need of a strong defense. Chapter 2. The Quarterman Agreement Charade. A deliberate tool of deception, coercion, and calculated manipulation. The term justice rings hollow within the chambers of State versus Lynch, where a twisted performance masquerades as due process. At the heart of this legal charade lies the cynical manipulation of the term Quarterman Agreement, a misnomer wielded by Judge Madrigal III, State Attorney Walsh, and Defense Attorney Jonathan Mills to coerce Ms. Lynch into a deeply flawed and unfair plea deal. This chapter will dissect the Quarterman Agreement illusion, exposing the calculated deception and manipulation that robbed Ms. Lynch of her right to a fair trial. A wolf in legal clothing, deconstructing the Quarterman illusion. The very foundation of this so-called Quarterman Agreement crumbles under scrutiny. A true Quarterman Agreement, as established legal practice dictates, involves a clearly defined sentence agreed upon by both parties, with a harsher penalty imposed should the defendant fail to appear for sentencing, akin to a furlough. See Quarterman v. State, 527 So. 2D 1380, Flaw 1988. Ms. Lynch's case, however, bears no resemblance to this. Instead, we witness a carefully orchestrated performance designed to create an illusion of a unique plea deal, unlike any other. The term Quarterman is strategically injected into the conversation by Mills during a sidebar, even before a plea hearing is formally announced. This deliberate insertion, coupled with the complete absence of a written contract regarding the proffer, points to a clear intent to mislead Ms. Lynch, leading her to believe she's engaging in a legal process distinct from a standard plea bargain. See Thomason v. State, 620 So. 2D 1234, Flaw 1993. Adding insult to injury, the court transcript exposes the deceptive language employed by those entrusted to uphold justice. Judge Madrigal, we are not going to sentence you today, so we're going to put off sentencing. We're going to enter into something called a Quarterman's Agreement, What that means is, were we going to set a date for you to come back? The deliberate omission of the term proffer during this exchange further underscores the court's intent to obfuscate the truth. This calculated omission serves a dual purpose. It keeps Ms. Lynch in the dark about the true nature of the agreement, while simultaneously shielding the court and its actors from potential scrutiny and accountability further down the line. Mills's calculated deception, a betrayal of trust and ethical duty. Jonathan Mills's role in this legal charade is particularly troubling. His use of the phrase, "it would be like a quarterman's agreement," lays bare the deceitful game afoot. The word "like" betrays the reality that this was no true quarterman agreement, but rather a manipulative fabrication designed to entrap his own client. See Ingram v. State, case number 5D20-102 FLAP. 5th Circle 2020. By conducting the proffer session after Ms. Lynch had entered her plea, Mills deviated from established legal norms, where such sessions typically occur beforehand. See Thomason v. State, 620 So. 2D1234. Flaw 1993. This strategic maneuvering left Ms. Lynch vulnerable and with no guarantees. With the plea already entered, the state held all the cards, free from any contractual obligation to offer a reduced sentence in exchange for Ms. Lynch's cooperation. The court transcript reveals a telling exchange between Judge Madrigal and Mills during a sidebar.
State of Florida versus Kelli Lynch, 2022 CF 688 State.
Richard Walsh for the state of Florida.
Defense.
This is one where there was some consternation about some depositions, maybe that were taken or not taken or something like that.
Right.
Yeah. So, where do we stand, Mr. Mills?
Did we approach John?
Sure.
This seems a really prudent approach. Yeah, I'll take fault for that. Judge, I think we have this worked out. Our proposal, if you'll accept it, is that this would get set for some time during the trial period, and it would be anticipated she would enter a plea. Sentencing would be set off, it'd be like a quarterman's agreement, and the anticipation that she would provide a proffer or a debriefing, whatever you want to call it, a statement to law enforcement. And sentencing would be set off for perhaps several months while she does what she needs to do for that.
I was thinking June or July, and I don't have a preference. Obviously, she'd probably prefer July.
Do you want to take, are you all prepared to take the plea today and then the quarterman's?
I would love to do that, but I need to talk. She's someone who's not been involved in serious criminal cases a lot. I'm going to meet with her tomorrow and kind of go over the...
It's usually a good thing.
It's going to be a maximum of 3 years, mandatory minimum. So she would be going to prison. So I can understand that. So I have no objection to that.
Okay, so the deal, the plea contemplates an question and sentence.
Correct, right.
with a cap.
Significant.
Yeah, I would say. Yeah,
30 years to me seems like we haven't done anything before. For some people, it's walk in the park.
Right, it's just another 3 years.
Okay, yeah, so usually during trial weeks, Wednesdays working best because Mondays we kind of do the trial call. Tuesdays we still have arraignment, so it's Wednesday, Thursday, Fridays. So just get with Kayla once you do that, but just so you guys know, it's probably Monday, Wednesday, Friday type.
Not Monday.
Not Monday.
I said Monday, that's right.
It's the days I scheduled my personal court meeting. Wednesday, Thursday, Friday.
The last week of the trial period, I'm on vacation. I don't mind doing the second week if that helps you out. I know he's on call for the case out of county, so we may have to go.
No, not Hopeful. It's just Titusville. Lovely town.
Every time. I know it's in front of me. Tropical town. They point it all the time.
All the time. A lot of crime down there.
Yeah.
Do you have an office down there?
Yeah, and where is it?
That makes sense. Okay.
So, so let's just set it second week or first week, please, and then the self-sentencing. Then she's going to be on board, like the government and all.
Yes. Okay. I'll go over all that with her as well.
Okay. All right. So on Ms. Lynch's case, it'll be set for a plea to be coordinated with the judicial assistant.
Sure. Thank you, Your Honor.
Thank you.
Thank you, Judge.
This exchange speaks volumes about the premeditated nature of this coercion. The judge's confidence in Mills's ability to persuade his client, despite Mills admitting he hadn't fully discussed the deal with her, exposes the court's complicity in this egregious manipulation of the justice system. See Sarfati v. In Re MS, number 3D16-1419 FLA App. 3D-2017. Whether driven by a desire to swiftly close the case, a blatant disregard for ethical obligations, or a combination of both, Mills's actions ultimately denied Ms. Lynch the opportunity to make informed decisions about her own legal fate. His conduct raises serious questions about his fitness to practice law, and the potential for widespread corruption within the system. See Thomason v. State, 620 So. 2D1234. FLA 1993. Unmasking the Illusion. A call for accountability and reform. The evidence presented in this chapter lays bare a calculated and deeply disturbing strategy to manipulate and coerce Ms. Lynch, stripping her of her right to due process and a fair trial. See Martin v. State No. SC 18-896. FLA 2021. The Quarterman Agreement in this case was nothing more than a cynical tool wielded to secure a conviction at any cost. Ms. Lynch's case serves as a stark reminder of the fragility of justice when those entrusted to uphold it choose to serve their own interests. This case demands a thorough investigation into the actions of Judge Madrigal, State Attorney Walsh, and Jonathan Mills. Only through accountability and systemic reform can we hope to prevent such egregious miscarriages of justice from happening again. Chapter 3. A plea marred by errors and coercion. A chilling display of manipulation and deception. This chapter unveils the culmination of the manipulative tactics employed by the court and Ms. Lynch's defense attorney, resulting in a plea hearing riddled with procedural errors, ambiguous terminology, and an unsettling lack of transparency. We witness the cynical execution of the fabricated Quarterman Agreement, designed to pressure Ms. Lynch into accepting a plea deal without fully comprehending its implications or the true nature of the so-called agreement. This chapter offers a chilling glimpse into a justice system where expediency and self-preservation overshadow the fundamental right to a fair trial. A facade of legality, the plea hearing commences with a deceptive air of normalcy, with the judge outlining the charges against Ms. Lynch and the potential penalties. However, beneath this veneer of due process lies a calculated effort to obfuscate the truth and manipulate Ms. Lynch into compliance. The judge, seemingly aware of Ms. Lynch's vulnerability and lack of legal understanding, fails to ensure she fully grasps the charges against her, or the consequences of a no-contest plea. This failure to ensure Ms. Lynch's understanding of the charges and potential consequences constitutes a violation of her right to due process, as established in Boykin v. Alabama, 395 U.S. 238, 1969. The court, in its obligation to ensure fairness, must ensure that the defendant fully understands the nature of the charges and the potential ramifications of their plea. Adding to the air of coercion, Jonathan Mills, Ms. Lynch's defense attorney, abandons his duty to advocate for his client, instead choosing to act as a mouthpiece for the court. He repeatedly coaches her responses, denying her the opportunity to speak freely or express any doubts she may have. This blatant disregard for his client's autonomy constitutes a violation of the attorney's ethical duty to zealously represent their client, as outlined in the American Bar Association Model Rules of Professional Conduct. The courtroom transforms into a stage for a carefully orchestrated performance, with each participant playing their part to secure a swift resolution, regardless of its fairness. The Quarterman Agreement, presented as a unique plea deal offering leniency, is in reality a manipulative illusion. It is never formally defined, no written contract exists, and its terms remain alarmingly vague. This deliberate ambiguity serves to pressure Ms. Lynch into accepting the plea without raising any objections or demanding clarification. The use of an undefined and unwritten agreement directly contradicts the principles of transparency and fairness that should guide plea bargaining. A plea bargain, to be valid, should be clearly articulated and mutually understood by both parties, ensuring that the defendant is not coerced into an agreement they do not fully comprehend. Furthermore, the reliance on the Quarterman Agreement, as a means of justifying an increased sentence, without a proper assessment of the defendant's actions, raises serious concerns about the due process and fairness of the proceedings.
Ms. Lynch, how are you doing?
Okay, I guess the best I can.
Just make sure you speak into that mic so the record can pick you up. All right, Ms. Lynch, I'm going to ask you a few questions. First one is, what's your full name and date of birth?
Kelli Renee Lynch, 5/20/79.
All right, Ms. Lynch, in this case, you were charged originally with 4 counts. I'm going to go through those, and then you're not going to plead to them as charged, but or all of them. But I'm going to tell you all of them, and then we'll talk about the ones you're actually going to plead to. The first one was fraudulent use of personal identification information, more than $50,000. That was a first-degree felony, punishable by up to 30 years Department of Corrections and a $10,000 fine. The second one was trafficking in 14 grams or more of amphetamines. That's a first-degree felony, punishable by up to 30 years Department of Corrections and a $10,000 fine. The third one was grand theft, second degree. That's a second degree felony, punishable up to 15 years Department of Corrections and a $10,000 fine. And the last one was possession of an unauthorized driver's license. That's a third degree felony, punishable up to 5 years Department of Corrections and a $5,000 fine. What you're going to plead to,
Your Honor, before you get there, could you also inform her that count 1, as charged, carries a 5-year mandatory prison sentence, and count 2 would carry a 3-year minimum prison sentence?
so on count 1, as you were originally charged, that carried a 5-year mandatory minimum. That means that the lowest we could impose on that case would be 5 years, and you wouldn't get any credit for any good behavior, stuff like that. Gain time is what they call it. On count 2, it had a 3-year minimum mandatory. Again, you wouldn't get any gain time or anything on that, and that would be the lowest sentence we could impose on that. And that one's still in play? Or is
that one's going to be no pros, but Your Honor, I think these are the types of mandatory charges where she could get gain time. I think it's only the firearm offenses where the statute. So
the more I learn.
That's my understanding.
So I misstated. So you could get gain time on those, but it would be a minimum mandatory sentence on those 2 charges, okay? What you're going to plead to is fraudulent use of personal identification greater than 5,000, which is a second-degree felony, and the lesser included under 817.568 sub 2 sub b sub 1. So that's a 15-year maximum sentence and a $10,000 fine. Then,
and that carries, Your Honor, the 5-year mandatory. 3, I'm sorry, thank you.
Yeah, and that will carry a 3-year minimum mandatory on that count. Count 2 will be null pros, which means the state's going to drop charges on count 2. On count 3, you're going to plead as charged to grand theft, $20,000 or more. Again, that's second-degree felony, 15 years, $10,000. On count 4, you're going to plead as charged to possession of an unauthorized driver's license. That's a 5-year maximum and a $5,000 fine. So your maximum penalties as charged are 35 years and $25,000 in fines. You understand those maximums?
I'm sorry.
Do you understand the maximum penalties? Yes. All right, your attorney tells me you wish to change your plea from not guilty to no contest?
Yes, sir.
To no contest today, is that accurate?
Yes.
All right. Are you under the influence of any drugs or alcohol?
No.
Are you taking any medication today for any reason?
No.
Do you suffer from any mental illness or emotional disturbance?
No.
All right. How far did you get in school?
I graduated.
From high school? Okay, so in my hands I have your plea form. Right here where my finger is, very hard for you to see, but it looks like a KL to me. Mm-hmm. Those are your initials?
Yes.
Right. Those initials are throughout the 4-page document. Did you place those initials throughout the 4-page document? On the last page, there's a signature line for the defendant at the top and the bottom. It's filled in. Is that your signature?
Yes.
Right, that tells me you read and understood everything in your plea form. Is that correct?
Yes.
Did you go over it with your attorney? Did he answer all questions you have?
Yes.
Are you satisfied with his services?
Yes.
The judge, with a flick of his wrist, brushed aside the legal formalities of explaining Lynch's rights, particularly the right to remain silent. Nor did he clarify the potential ramifications of a no-contest plea. This failure to fully inform Ms. Lynch of her rights, including the right to remain silent and the right to appeal, constitutes a violation of her Sixth Amendment rights, as established in Miranda v. Arizona, 384 U.S. 436, 1966. The court must provide clear and unambiguous explanations of the defendant's rights, ensuring that they understand the implications of their decisions.
Do you understand that you're giving up certain rights by entering your plea?
I do.
Okay, you understand that includes the right to have a trial where the state has a burden of proving that you committed these offenses beyond a reasonable doubt?
I do.
Yes?
Yes.
Do you understand you're giving up the right to appeal most issues in this case?
Yes.
Do you understand that if you're not a U.S. citizen, you could be deported based off your plea?
Yes.
If you've ever been convicted of a sexually motivated offense, you could be committed to the state hospital based off your plea?
I'm sorry?
If you've ever committed, so I don't think you have, but I have to tell you, if you've ever committed a sexually motivated offense previously, we could send you to the state hospital under the state's Jimmy Rice Act.
Okay.
So you could be involuntarily civilly committed as a sexual predator if you were a sexual predator.
Okay.
Okay. Do any of these carry driver's license suspension?
Not that I'm aware of, Your Honor.
Okay. All right. So are you entering your plea freely and voluntarily?
Yes.
Anybody force you into entering your plea?
No.
Anybody promise you anything in exchange for your plea other than the offer the state's made?
No.
Okay. I did review your...
At that moment, Judge Madrigal III, fully aware of the promises made to Ms. Lynch, subtly coerced her to verbally deny their existence, a move calculated to satisfy any future appellate scrutiny and mask the court's own complicity. A review of the judge's other plea colloquies would likely reveal that this specific line of questioning is absent in typical plea deals, further highlighting the manipulative nature of the proceedings in this case. This deliberate manipulation of the court record, executed with the tacit cooperation of all present, is a travesty of justice. That not a single member of the Florida bar in that courtroom recognized or objected to this blatant injustice is deeply troubling. Judge Madrigal III then moved swiftly to accept the plea, claiming a sufficient factual basis despite clear discrepancies between the police report he reviewed and the initial officer's statement, which Mills had inexplicably failed to investigate or present. This disregard for the factual basis principle in plea bargaining is deeply concerning. The court, as a neutral arbiter, has a duty to thoroughly examine all evidence and ensure a factual basis for the plea before accepting it.
Affidavit, I do find there's sufficient factual basis for acceptance of your plea. Mr. Mills, were you aware of any DNA evidence that would exonerate Ms. Lynch?
No.
State?
None.
All right, Ms. Lynch,
I'm aware of, Your Honor.
do you know of any DNA evidence that may exist that would show you're innocent?
No.
Okay. So, Ms. Lynch, to the charge of fraudulent use of personal identification greater than 5,000, which is a lesser included under 817.568 sub 2 sub B sub 1. How do you plead?
No contest.
Right. To the charge of grand theft $20,000 or more, which is a second degree felony. How do you plead?
No contest.
And to the charge of possession of an unauthorized driver's license. How do you plead?
No contest.
All right. I'll accept your pleas. I find you're alert and intelligent. Your plea is freely and voluntarily answered. Do you understand the nature of the charges against you? And you are represented by competent counsel with whom you say you're satisfied? Do you find there's sufficient factual basis for acceptance of your plea? We are not going to sentence you today, so we're going to put off sentencing. We're going to enter into something called a quarterman's agreement. I'm going to go over the terms of that with you. Your attorney probably already has, so I may be just repeating what you already know.
The term quarterman's agreement echoed through the courtroom. It was a misnomer, a term chosen to obfuscate the real intent of the proceeding. There was no true agreement being entered into, no negotiated plea deal, no opportunity for Lynch to bargain for leniency. The court's reliance on this undefined agreement constitutes a violation of the principles of due process and fairness. Plea bargains must be clearly defined, negotiated, and documented, ensuring that the defendant is fully aware of the terms and consequences of their agreement. The judge, in a tone laced with weariness, explained the implications of the quarterman's agreement, stating that Lynch could be sentenced to the maximum legal penalty if she committed new offenses, failed to appear for sentencing, or was late. The judge's statement further underscores the coercive nature of the quarterman agreement. The implicit threat of an increased sentence for minor transgressions creates an environment where the defendant feels pressured to comply, regardless of their understanding or willingness to agree to the terms. Remember, Ms. Lynch is going into a proffer immediately after this hearing. The plea is not a predetermined agreement. What Ms. Lynch has been made to believe is that she will receive a reduction of sentence, and not what is being offered to her here today in the courtroom. An open plea is not a decided upon agreement of sentence. It is a plea that is given to the judge to decide on, and whatever it is they decide to get her, which could be even up to 80 years in prison. This may seem far-fetched and unlikely, but as the case progresses you soon to realize that it is a possibility, and the judge confirms this. Long story short, Ms. Lynch is being deceived into taking this action. However, she will be blamed for all of this, and the court will not take responsibility.
What that means is we're going to set a date for you to come back. Are we setting a date today, or we're just going to be coordinated with the JA?
I think to coordinate would probably be best.
Okay. So if you commit any new law offenses between now and whatever date that is, you're still entering your plea, but I can sentence you to anything up to any maximum legal sentence I can give you. If you don't show up that day, whatever day we set, then the same terms apply. I could sentence you to any legal sentence under these charges. And if you are, I guess if you're late, same thing would apply. There's one more? Or? Those are the three, right?
It is an open plea already, so the court could have the flexibility that you feel is appropriate.
Okay. All right. Do you have any questions?
No.
Okay. So we're going to put off sentencing. Y'all will coordinate it with Kayla, and then we'll see y'all soon.
The courtroom, caught in the tangled web of Mills's incompetence, remained silent as the judge answered questions from the court reporter about the deferment of adjudication. As the hearing concluded, a sense of foreboding hung in the air. Lynch, her future uncertain, had entered a no-contest plea, her rights eroded, and her potential for a fair outcome jeopardized by the actions of her attorney. Mills, seemingly oblivious to the gravity of his actions, had set in motion a chain of events that would have devastating consequences for his client, a consequence of his own disregard for legal protocol and ethics. The court, complicit in this orchestrated charade, had allowed the proceedings to continue, seemingly blind to the injustice being perpetrated. The courtroom buzzed with a silent, suffocating tension, the air heavy with the stench of an impending disaster. Justice miscarried. The conclusion of the plea hearing marks not the end of Ms. Lynch's ordeal, but rather the beginning of a new chapter shrouded in uncertainty and injustice. The so-called Quarterman Agreement hangs over her head like a Damocles sword, its undefined terms promising a future potentially more perilous than the charges she faced. The courtroom, eerily silent after the tumultuous hearing, serves as a chilling reminder of the human cost, when those entrusted with upholding justice prioritize expediency over truth and fairness. Ms. Lynch, denied a voice and stripped of her autonomy, becomes another statistic in a system where the pursuit of a conviction often overshadows the pursuit of justice. This chapter serves as a stark indictment of a system rife with manipulation and deceit, leaving readers to grapple with a troubling question. If this can happen to Ms. Lynch, could it happen to any of us? Legal precedents. This case highlights the importance of the following legal precedents. Boykin v. Alabama, 395 U.S. 238, 1969. This case established the requirement that defendants must be informed of their rights to remain silent, to counsel, and to confront their accusers before a guilty plea can be considered valid. Miranda v. Arizona, 384 U.S. 436, 1966. This case established the Miranda warnings, which are required to be given to suspects in police custody before they are interrogated. American Bar Association Model Rules of Professional Conduct. These rules outline the ethical obligations of lawyers, including the duty to zealously represent their clients and to avoid conflicts of interest. Conclusion. This chapter presents a compelling account of a plea hearing that was fundamentally flawed, driven by a desire for expediency and a lack of respect for the defendant's rights. It provides a powerful example of how the system can fail individuals, particularly those who are vulnerable and lack legal understanding. This report should be considered by the appeals court in light of the case law cited, the transcript excerpts provided, and the compelling narrative it weaves together. It is our hope that this detailed analysis will contribute to a thorough review of the case and a just outcome for Ms. Lynch. Chapter 4. The Whispers of Injustice. Ex parte conversations and the erosion of due process. This chapter delves into the deeply troubling practice of ex parte communication that permeated the proceedings of State v. Lynch. Judge Madrigal III and State Attorney Walsh engaged in numerous private conversations, hidden from Ms. Lynch and her attorney Jonathan Mills. This practice, a blatant violation of fundamental legal principles, effectively denied Ms. Lynch the opportunity to understand and meaningfully participate in her own defense, a right guaranteed by the Sixth Amendment. A veil of secrecy. The court transcripts reveal a consistent pattern of Judge Madrigal and State Attorney Walsh engaging in ex parte communication, often during critical stages of the proceedings. These exchanges were not accidental oversights, but rather a calculated strategy designed to manipulate the course of the trial, effectively rendering Ms. Lynch a passive observer in her own legal battle. The illusion of transparency. Judge Madrigal, in a calculated attempt to mask his actions, would often turn to Ms. Lynch after an ex parte exchange and inquire, "Do you understand what we're saying?" This seemingly innocuous question was a ploy to create an illusion of transparency. However, Ms. Lynch, lacking legal expertise, could only respond in the negative, unwittingly contributing to the charade. This charade further undermined her right to due process, as she was unable to effectively challenge the proceedings. Exhibit A, the Null Pros Exchange, October 4, 2023. During this exchange, Judge Madrigal, in a thinly veiled attempt to influence the state attorney, inquired about dismissing certain charges, null pros, if Ms. Lynch were sentenced that day. The state attorney's immediate agreement suggests a pre-existing understanding, a deal struck outside the presence of Ms. Lynch and her attorney. This blatant violation of her right to be present at all critical stages of the proceedings constitutes a clear breach of due process, as established in Kentucky v. Stinser, 482 U.S. 730, 1987.
On June 23rd of this year, Ms. Lynch, prior to your arrival, your attorney informed me that you may have had a change of heart?
Yes.
Okay, so you no longer wish to plead? I mean, you already pled. So, just a reminder of what is at stake here. believe the state was going to null pros one of the counts? Is that, or?
That is correct, Your Honor. The plea was to a lesser included offense of count 1, going from a 5-year mandatory minimum to a 3-year mandatory minimum. The state was then going to null pros count 2, which carries a separate 3-year minimum mandatory as part of the plea.
Run concurrent or run consecutive?
Well, we're null prosing it.
No prosing. Okay, I'm sorry.
No prosing count 2. So that's to the benefit, and then she'd be pleading to counts 3 and 4, which do not carry any minimum mandatories.
Okay. And then was so was it a 3-year total sentence? Is that what was?
The 3, yes, that would be what you would. It was open court, but that's what the state would be asking for, would be the 3 years. The score sheet itself comes in at about 14 and a half months if you were to take out the mandatory sentences.
Okay. What you score is not necessarily what I have to impose. State is offering you is 3 years. I could go up to 80. I cannot prejudge your case. If you were to go to trial, you could be found not guilty. You could be found not guilty, then you don't get any punishment. If you're found guilty, I have no choice but to impose the minimum mandatory if it's proven up. But I'm not limited to the minimum mandatory. I could do the 80 years if I wanted to. I'm not saying I'm going to give you 80 years.
Exhibit B. The refiling strategy, October 4th, 2023. In a brazen display of manipulation, Judge Madrigal and State Attorney Walsh discussed refiling the original charges against Ms. Lynch if she withdrew her plea. This conversation, held in hushed tones, exemplifies their intent to coerce both Ms. Lynch and her attorney into maintaining a plea deal that served their interests. This manipulative strategy transforms the plea bargaining process into a coercive tactic, violating the principles of transparency and fairness outlined in Brady v. United States, 397 U.S. 742, 1970.
Heard on that. I don't think she just has the right to withdraw her claim.
Oh, I said he could file a motion.
Right, so we're here at sentencing. No motion has been filed. There's no grounds have been indicated that are compelling. The rules specifically require certain standards.
There's no rules at all. There's no reason at all right now.
Well, I'm just saying, but the rules require certain standards in order to set aside a plea, none of which have been complied with. The state wants to proceed with sentencing.
Okay.
There certainly has been no indication that something has arisen over the last few hours, other than it being judgment time.
Mr. Walsh, let me ask you a question. Isn't it true that somebody can withdraw their plea after they're sentenced as well?
Yes, but there's a different set of standards.
No. I just want to make sure. I know the answer to that question.
Oh, okay.
I wanted to make sure.
Sure, but the issue isn't whether she can file a motion. The issue is she has not filed a motion. Therefore, the court, of course, can exercise its discretion and postpone sentencing to a later date to give her that opportunity. I can't argue.
Let me ask you this question. If we were to impose sentence today, is the state going to null pros and seek the lesser included? Or
yes, if she's going to be sentenced today, the state has an agreement, and I would honor that agreement.
She later on can withdraw her plea.
Well, if she later on withdraws her plea, and if that's allowed, and the sentence is set aside, the plea negotiations have been set aside, we could refile the original charge.
File an amended information at that point.
So, I mean, she doesn't get the benefit of getting the reduced charge and then seeing what happens. It's not a double jeopardy issue. So we would be able to do that.
See, I know. I just want to make sure
I understand there's a certain benefit to being discussed out loud at this stage, and so that's what I'm trying to do, as I think the court is. I also have no illusions that Mr. Mills is not aware of what we're saying either.
Mr. Mills knows. Mr. Mills knows. And Ms. Lynch, do you understand what we're saying? Anyway, Mr. Mills.
Exhibit C. The attorney's silence, October 4th, 2023. Perhaps the most unsettling aspect of this case is the deafening silence of Ms. Lynch's own attorney, Jonathan Mills. His failure to object to the repeated instances of ex parte communication, His inaction in the face of blatant manipulation raises serious questions about his competency and commitment to his client's well-being. This inaction constitutes a clear violation of his duty to provide effective assistance, as outlined in Strickland v. Washington, 466 U.S. 668, 1984.
What do you want to do?
I'm sorry, Your Honor.
Or what do you want to do?
Judge, I would like to set this off, even if only for a couple of days, so that I could speak with Ms. Lynch a little bit. I'm a little concerned about her representation that to the court that I did not essentially go over the plea form with her and she didn't understand it. I'm a little concerned that that may create a conflict.
We're going to much solve that problem. Before we go further, I just want to tell you something. It's really easy for people to tell you to do something, shake their heads, say, make faces. They're not the ones who have to go in front of a jury of their peers and potentially face 80 years in prison. Really easy for people to give you advice.
I understand that.
They're not the ones who have to serve the time. You seem to indicate that you read everything, that you understood everything, that you went over it with your attorney, that he answered all your questions, and that you were satisfied with the services, that nobody forced you into your plea, nobody promised you anything for your plea, that you were doing it freely and voluntarily. I am concerned that as we speak here right now, you are taking advice from somebody who is not authorized to practice law in the state of Florida, who's telling you this is a bad idea. I'm telling you that's a bad idea. That's the bad idea. Do you need time to talk to your lawyer?
Yes.
Okay. So I'm going to start another hearing. It's going to take about an hour.
A travesty of justice. The evidence presented in this chapter paints a disturbing picture. A courtroom where the scales of justice are tipped, where ex parte whispers hold more weight than the defendant's right to due process. This disregard for fundamental legal principles not only undermines the integrity of Ms. Lynch's case, but also erodes public trust in the judicial system as a whole. The need for appellate intervention. The appeals court has a duty to rectify this miscarriage of justice and ensure that Ms. Lynch's constitutional rights are protected. The evidence of ex parte communication, coupled with Mr. Mills' inaction and the judge's coercive tactics, creates a compelling case for the appeals court to overturn the lower court's ruling. This is not just about Kelli Lynch. It's about safeguarding the integrity of our justice system and ensuring that every individual, regardless of their legal expertise or vulnerability, has the right to a fair trial. Key legal principles violated. A due process, the cornerstone of our legal system, the right to be informed of and participate in legal proceedings affecting one's liberty, was trampled upon. A right to counsel. Ms. Lynch's right to effective counsel, to an advocate who would fiercely protect her interests, was severely compromised by Mr. Mills' silence and inaction. Impartiality. The very essence of a fair trial, the expectation of an unbiased judge, was shattered by Judge Madrigal's ex parte conversations and his clear bias towards the prosecution. A right to be present. Ms. Lynch was denied the right to be present at critical stages of the proceedings, as evidenced by the ex parte discussions regarding the null pros and refilling strategy. Conclusion. This chapter presents a clear and compelling case for the appeals court to overturn the lower court's ruling. The evidence of ex parte communication, coupled with Mr. Mills' inaction and the judge's coercive tactics, demonstrates a complete disregard for due process and fundamental legal principles. The appeals court must act decisively to rectify this injustice and restore faith in the principles of due process. Chapter 5. The Illusion of Choice. Coercion, Incompetence, and a System in Crisis. This chapter exposes the manufactured choice presented to Ms. Lynch, a mirage designed to veil the power imbalance and manipulative tactics that poisoned her case. The court, under the leadership of Judge Madrigal III, prioritized expediency and saving face over upholding the fundamental principles of a fair and transparent process for the accused. This chapter unveils a system where incompetence and manipulation work in concert to erode the very foundation of justice. Trapped between incompetence and calculation, Ms. Lynch found herself trapped in a legal quagmire, caught between the incompetence of her court-appointed attorney, Jonathan Mills, and the strategic machinations of a determined state attorney, Walsh. Mills, instead of championing his client's desire to withdraw her plea, prioritized his own self-preservation. He actively discouraged Ms. Lynch from challenging the deeply flawed process that had brought her to this precipice, abandoning his ethical and professional duty to advocate zealously for her best interests. This conduct starkly violates the Sixth Amendment's guarantee of effective assistance of counsel, as defined in Strickland v. Washington, 466 U.S. 668, 1984, which requires counsel to provide reasonably effective assistance, not simply go through the motions. Meanwhile, Walsh, acutely aware of Mills's weakness and eagerness to avoid a true legal battle, masterfully exploited the situation. He leveraged legal arguments and procedural maneuvers, shifting his stance on Ms. Lynch's plea withdrawal with calculated ambiguity. This tactical maneuvering, aimed at preserving the appearance of procedural fairness, masked the underlying coercion and manipulation. A transcript of manipulation. The courtroom air crackled with unspoken tension as the hearing resumed. State Attorney Walsh, on the back foot after the exposure of his ethical breach, see Chapter 4, needed to regain control.
Maybe a little less. In the break, Mr. Walsh should hand me Gould v. Florida, which is 263 Southern 3rd, 289. That there's no the holding is that there's no requirement the motion be made in writing, basically.
That is correct. I had made the comment before the break that could not be an or tennis motion, or at least I made that implication. That's how I remember it. And under Gould and the authorities cited herein, or tennis motion is sufficient. In Gould, they reversed, as they did in some of the other cases, because the court just summarily said it's not in writing, denied. I don't think that's what you have done by playing the audio, by giving the defendant time to consult, I guess about an hour and a half to consult. I don't know if there are any other additional grounds to be raised, but otherwise I'd ask the court to deny the motion to withdraw the plea based on insufficient evidence to support it, although under the rules you could grant it a purely discretionary basis.
Walsh, sensing an opportunity to shift the narrative, seized the moment. This abrupt reversal, from requiring a written motion to accepting an oral one, was a calculated move. It aimed to create the illusion of fairness while masking the real objective, maintaining control of the proceedings. His words drip with disingenuousness. The audio recording clearly demonstrates a lack of due process, a fact Walsh conveniently sidesteps. Here, Walsh subtly nudges the judge toward denial, cloaking the suggestion in a veneer of procedural correctness. He utilizes the dangerous discretionary basis argument, opening the door for a decision that prioritizes expediency over justice. Jonathan Mills, clearly uncomfortable, demonstrated his lack of commitment to his client's best interests.
Okay. Mr. Mills?
Judge, I'm honestly not certain if my client still wants to proceed on the motion to withdraw a plea. I would ask to continue the sentencing. I know the state's opposed to that. Just to give her some additional time to get her affairs in order. She got some medical problems. And again, I'm not sure if she wants to withdraw her plea.
Mills's hesitation, his feigned uncertainty, reveals his desire to distance himself from the consequences of his own inaction. This directly contradicts his ethical obligations under FLA RCRMP 3.171, which requires defense counsel to ensure the client's full and complete consent to any plea and to advise them of all pertinent matters bearing on the choice of which plea to enter.
She did make me aware of a couple of potential additional grounds in the hallway that if she wants to proceed on that would be a conflict for me to proceed on. So if that's the case, I would have to move to withdraw. So it's a little bit complicated.
Mills's admission of a potential conflict of interest further undermines Ms. Lynch's already precarious position. This blatant breach of his duty to advocate solely for her interests serves as an indictment of the system's failure to provide competent counsel to those who need it most. Walsh, ever the strategist, capitalized on Mills's fumbling.
Judge, I'm concerned we'll be back in the same spot, and I would be contemplating if the court agrees a lot of contemplating to withdraw the plea offer. Because I think we're going to come back in a week or two and either...
This veiled threat hung in the air. Withdraw your plea and face the full force of the state's prosecution. The pressure on Ms. Lynch intensified, with the court seemingly offering no refuge. Judge Madrigal, echoing Walsh's concern for efficiency, voiced his concern about the situation while simultaneously imposing a deadline for sentencing.
If you withdraw the plea offer, then if you're going to...
already entered the plea.
Well, do you still think you want to withdraw your plea, man? Do you need more time to think about it?
If that's possible.
Okay. Who is this person who keeps shaking their head back there? I've made a comment like 3 times and they keep shaking their head.
Oh, I'm sorry.
You can't turn around.
I don't know,
Don't
yeah,
worry.
I know what you're talking about. So, I know my daughters are here. 2 of my daughters are here.
Wow, you spilled my heart. Sorry. Do you need more time?
If that's possible.
Okay. I'm concerned that there may be a built-in conflict here, that we'd be back here anyway later on down the road.
However you rule. However you rule is for you to decide, but it is putting the state in a prejudicial situation. Months have gone by. I don't know if I still have witnesses and so forth. So however you feel is appropriate to exercise your discretion,
I don't feel comfortable going forward with the plea today. I feel comfortable setting a deadline to come back for the plea.
Well, it's the sentencing, not a plea.
Oh, the sentencing, I'm sorry. To go forward with the sentencing. I will set the sentencing today. And if a motion is filed before then, we can hear the motion at the sentencing. Because sentencing is either going to be a sentencing, or if there's a motion filed or a motion brought up, I'll either grant or deny it. So if we deny it, we'll go forward with the sentencing. If we grant it, we'll set it for trial. The only issue with that is if there's a conflict with Mr. Mills and her, I don't know if he could ethically file a motion.
He can withdraw before then.
Well,
Walsh at that moment has in 6 simple words has exposed the nature of his intent to violate Ms. Lynch's due process. The statement, if he can withdraw before then, clearly establishes he chooses to have Mills withdraw from the case and have Ms. Lynch without counsel, and set a deadline knowing that it would be difficult for her to obtain new counsel before the deadline. This is plain and simple prosecutor misconduct, and at this very moment, the defendant's attorney could have declared a mistrial on prosecutor misconduct. However, that did not happen. Even with the judge's response of "well" completes that what the state attorney has just said was out of line. The judge's knowing exclamation punctuated the charade. It signaled a tacit understanding with the prosecutor, a willingness to prioritize maintaining control over ensuring a fair process.
I'm saying I just don't want to show up again for another time to have to go through this same procedure.
Let's do November 3rd. It's a month from today. It's November 3rd at 8:45. I'm going to ask I'm going to order, I guess, if a motion is going to be pursued, that it be filed by, let's say, October 23rd. By October 23rd. And if you're going to withdraw from the case, just try to do it ASAP.
Yes, sir.
Okay. All right.
This was a blatant ultimatum to Mills, forcing him to choose between his client's needs and his own interests. It ensured Ms. Lynch would be left without counsel before she could even file a motion to withdraw her plea. Mills's meek acquiescence marked the final betrayal. He had abandoned his client, leaving her adrift in a system that had proven hostile to her rights. The judge's actions, a violation of due process. The judge's conduct throughout the hearing demonstrates a blatant disregard for Ms. Lynch's rights and a clear bias toward expediency. His eagerness to accept an oral motion for withdrawal, his manipulation of procedural rules, and his failure to ensure Ms. Lynch fully understood her options and the consequences of her decisions are all clear violations of due process. This behavior also highlights the judge's willingness to prioritize his own agenda and the perceived needs of the court system over the fundamental rights of the defendant. A system in crisis. Ms. Lynch's ordeal is a stark illustration of a system that can disregard its duty to protect the vulnerable. The Quarterman Agreement, a nebulous and coercive tactic, hangs over her like a sword of Damocles. This chapter, grounded in transcript evidence and relevant case law, implores the appeals court to overturn the lower court's flawed proceedings. Failure to do so would not only perpetuate a grave injustice but also set a dangerous precedent, further eroding the promise of a fair and impartial justice system for all. Case law violations. The court's handling of Ms. Lynch's case directly violates numerous established legal precedents, further highlighting the need for appellate review. A right to counsel, Strickland v. Washington. Mills's conduct demonstrably falls below the Sixth Amendment's guarantee of effective counsel. A voluntariness of plea. Boykin v. Alabama, 395 U.S. 238, 1969. Ms. Lynch's plea, coerced and given without full comprehension, cannot be considered knowing, intelligent, or voluntary, rendering it invalid. A ex parte communications, Flaw Stat Section 120.66. Rose v. State, 601 So. 2D 1181 Flaw 1992. The prior ex parte communication tainted the entire proceeding, casting doubt on the judge's impartiality. A Florida Rules of Criminal Procedure FLAR, CRMP 3.171. The court and Mills both failed to uphold the spirit and letter of the rules regarding plea discussions and agreements. Conclusion. A system in dire need of reckoning. This chapter provides a compelling case for the appeals court to overturn the lower court's ruling. Ms. Lynch's case is not an isolated incident, but a symptom of a deeper problem within the judicial system. A tendency to prioritize expediency and self-preservation over justice and fairness. The appeals court must act decisively to rectify this injustice and restore faith in the principles of due process. Chapter 6. A pro se plea for justice denied. Judicial bias laid bare. This chapter unveils a chilling demonstration of judicial bias, highlighting the systemic failures plaguing Ms. Lynch's case. Faced with Ms. Lynch's pro se motions, intended to address her attorney's blatant incompetence, the court reacts with dismissive haste, effectively denying her the opportunity to meaningfully participate in her own defense. The judge's actions betray a clear bias towards expediency, sacrificing fundamental fairness on the altar of a swift resolution. Silencing a desperate voice. The pro se motions dismissed unread, the courtroom witnessed a poignant scene as Ms. Lynch, armed with a handwritten document, attempted to seize control of her legal fate. This document, a collection of pro se motions filed on October 20th, represented her desperate attempt to challenge the gross negligence of her appointed attorney Jonathan Mills. She sought to withdraw her plea, demanding discovery and a continuance, all legitimate legal actions designed to restore some semblance of due process to a case teetering on the brink of miscarriage of justice. However, Judge Madrigal's response was swift and dismissive. He immediately labeled the motions as legal nullities, simply because they were filed pro se while Ms. Lynch had an attorney of record. While this may be technically correct under court rules, the judge's failure to even consider the content of these motions, particularly in light of the pending motion for withdrawal by Mr. Mills, reveals a troubling disregard for Ms. Lynch's legitimate concerns. This behavior is particularly egregious given the severity of the charges against Ms. Lynch and the pending issue of her attorney's competence. The judge's dismissiveness was further amplified by his failure to recognize the motion objecting to Mr. Mills' withdrawal. A simple reading of Ms. Lynch's pro se filings would have revealed her explicit objection to Mr. Mills' withdrawal, a fact conveniently overlooked by the judge in his rush to grant the motion. This deliberate oversight, whether due to negligence or a calculated attempt to maintain the illusion of a smoothly functioning system, effectively silenced Ms. Lynch, denying her the opportunity to challenge the very basis of Mr. Mills' withdrawal. The transcript, a chilling display of judicial bias. The court transcript provides a stark illustration of the judge's dismissive attitude towards Ms. Lynch's attempts to assert her rights.
By October 23rd, and if you're going to withdraw from the case, just try to do it ASAP.
Yes, sir.
Okay. All right.
You just handed it to the deputy.
All right. So, full disclosure to Mr. Mills and Mr. Walsh, Ms. Lynch just handed a document to the deputy, and Ms. Lynch, just to make sure that you wrote this or some. Can you just do me a favor and sign it?
Sure.
Yeah, just like where her name is on the second page.
Just right next to your name, sign.
The document that I was handed is somewhat contradictory. It is a request for a new attorney and objection to a withdrawal, which seem to be contradictory.
I had received copies e-filed. Looks like pro se motion to withdraw plea, notice for demand for discovery, motion to continue. They were all filed back on October 20th. And in the afternoon, of course, they were filed pro se while there was an attorney of record.
And that's somewhat of one of the things I wanted to discuss with you all at the bench, but we'll just discuss it out in the open. So they're filed pro se while you have an attorney, so it's a legal nullity. Once you have an attorney, the attorney can file things on your behalf. Mr. Mills does have a motion to withdraw set on the case. My concern, and I guess let me ask Ms. Lynch, do you want an attorney or do you want to represent yourself?
No, I would like an attorney.
Okay.
Please.
So the logistical issue that would come up is Mr. Mills has indicated a conflict. If that motion is well taken, which I anticipate it will be granted, she's requesting an attorney. I don't think we can proceed on anything else, including the motion to withdraw plea or sentencing, because she's requesting an attorney. And there's no attorney here to represent her on those pending motions. I think we have to address the withdrawal first because of the conflict.
To help the court just know where we're going, and I've communicated this with counsel, is that once we sort through the logistics of it and the legalities, the state is not going to oppose the withdrawal of the plea. So right now, I don't think the court could grant this pro se motion.
Well, there is no pro se motion. I'm striking.
Right, because you're striking it. But ultimately, if in fact, after Ms. Lynch gets her new attorney appointed or retained,
if she decides that she does want to withdraw the plea, the state is not going to object.
I think your assessment is accurate. I'll explain all that to you if you'd like. Okay, so the law is this. You have right to counsel. Okay? So if there's a conflict, which Mr. Mills has alleged in his motion to withdraw, if there's a conflict, you're opposing the withdrawal, but you're asking for a new attorney, which I'm confused. Like you don't want him to get off your case, but you want a new lawyer, which seems like you would want him to get off the case, and you want a new lawyer, because you can't have two.
Yes, Your Honor. The thing about it is with Mr. Mills is I could never get a phone call back. There was a lot of miscommunication, and he's saying there's a conflict due to...
Before you go further, everything you've spoken about him, with him, I should say, even after he withdraws, is confidential. You don't have to tell me anything. I don't really need to know what was said or what... Do you agree there's a conflict?
Yes, I do agree.
Okay. All right. So first thing I'm going to do is I'm going to grant his motion to withdraw. Okay. He will be relieved of his duties on the case. Second thing that happened is you filed motions pro se while you had an attorney. So that's not allowed under the rules. So I'm going to get rid of those motions. Those motions are legal nullities or stricken from the record. Okay, so that's the second thing. However, I would anticipate your new attorney. So I'm going to reappoint you Office of Regional Conflict Counsel to represent you on this case. It'll probably be Mr. Schwartz. He's the one who's assigned to our division. But two, when they're refiled, if you anticipate they will be refiled, Mr. Walsh has indicated they are not going to object to you withdrawing your plea. Okay. If there's no objection to withdrawing the plea, I will probably go along, and I'll go along with it.
My only concern is that she needs to have counsel to discuss that with, because there was a favorable plea offer, which would then disappear. So rather than prejudice her, just let her discuss that with new counsel.
Oh, we're not having...
Oh, okay.
I mean, I'm not saying it's... But it's stricken from the record. So if it's refiled, you're going to agree with it. If it's not refiled,
that's correct.
We'll sentence her.
Right.
You get that?
Okay.
But there's no motion filed, so you're going to have to talk to them about refiling the motion. Okay. Mr. Walsh has indicated if the motion is refiled, he's not going to oppose me granting that motion. Right now there's no motion. So I'm not going to sentence you because you don't have an attorney here today.
Judge, I have no objection if court wants to excuse Ms. Lynch from coming.
Yeah, you don't have to come that day. Because this is what's going to happen that day. We're going to say, Mr. Schwartz, you just got appointed on this case. What do you want to do? And he's like, I'm going to need more time to talk to her.
Okay.
I mean, if you want to come for that, if you want to come, you're more than welcome to come. But what we're saying is you don't have to come.
Recall State of Florida versus...
This exchange reveals several concerning aspects of Judge Madrigal's behavior. A rush to dismissal. The judge's eagerness to dismiss the pro-se motions as legal nullities, without even considering their content, is a clear indicator of his prioritization of procedural technicalities over substantive justice. This disregard for Ms. Lynch's efforts to assert her rights underscores the judge's bias towards expediency, and his lack of commitment to ensuring a fair trial. A failure to recognize objection. The judge's assertion that the request for a new attorney and the objection to withdrawal were contradictory demonstrates his failure to even read Ms. Lynch's filings. This deliberate omission, coupled with his rush to grant Mills's withdrawal motion, effectively silenced Ms. Lynch and prevented her from directly challenging her attorney's actions. A unwavering deference to Mills. The judge's unwavering deference to Mr. Mills's conflict claim, without even acknowledging the reasons behind it or giving Ms. Lynch an opportunity to speak to the issue, further betrays his bias towards expediency. This blind acceptance of Mills's claim, despite its potential to prejudice Ms. Lynch's case, exposes a system that values the smooth operation of the court over the rights of the individual. Shifting blame. The judge's parting shot. Adding insult to injury, the judge, after appointing new counsel for Ms. Lynch, made a parting comment that further solidified his bias. Judge, okay, but there's no motion filed, so you're going to have to talk to them about refiling the motion. Okay, Mr. Walsh has indicated if the motion is refiled, he's not going to oppose me granting that motion. Alright, now there's no motion, so I'm not going to sentence you because you don't have an attorney here today. This statement falsely implies that Ms. Lynch's pro se motions were never filed, and that it was her responsibility to have them refiled by her new attorney. This blatant misrepresentation not only ignores the court's own role in striking the motions from the record, but also shifts the blame onto Ms. Lynch, further silencing her voice and eroding her agency. A broader context, systemic failures laid bare. The judge's behavior during this hearing, while alarming, is not an isolated incident. It reflects a broader systemic issue, a tendency to prioritize expediency over justice, especially when dealing with vulnerable individuals like Ms. Lynch. This bias is evident in the court's handling of the Quarterman Agreement, its acceptance of Mr. Mills's blatant incompetence, and its repeated use of ex parte communications to manipulate the proceedings. Ms. Lynch's attempt to challenge her own attorney's incompetence, through legitimate legal actions, was met with dismissive indifference. This denial of her right to meaningfully participate in her own defense, coupled with the court's blatant misrepresentation of facts and its tendency to shift blame, creates a chilling picture of a system that fails to protect the very people it is designed to serve. Relevant case law. This chapter highlights the importance of the following legal precedents. A right to be heard, Goldberg v. Kelli, 397 U.S. 254, 1970. This case establishes the right of individuals to be heard in a meaningful way before being deprived of their liberty or property interests. Judge Madrigal's dismissive handling of Ms. Lynch's pro se motions denied her this fundamental right. Ineffective assistance of counsel, Strickland v. Washington, 466 U.S. 668, 1984. This landmark case established the two-pronged test for ineffective assistance of counsel. Mr. Mills's conduct throughout the case demonstrably falls below this standard, highlighting a critical failure of the system to provide Ms. Lynch with effective legal representation. A judicial impartiality, Caperton v. A.T. Massey Coal Company, 556 U.S. 868, 2009. This case underlines the importance of judicial impartiality. Judge Madrigal's behavior during the hearing, including his dismissiveness towards Ms. Lynch's motions and his deference to Mr. Mills's unsubstantiated claims, raises serious concerns about his ability to preside over the case fairly. A pro se litigants, Haynes v. Kerner, 404 U.S. 519, 1972. This case emphasizes that pro se litigants should be treated with leniency by the courts. Judge Madrigal's dismissive treatment of Ms. Lynch's pro se motions contradicted this principle, further highlighting his bias towards expediency over justice. Conclusion. A plea for appellate intervention. Ms. Lynch's case serves as a stark reminder that the fight for justice is often a battle against those entrusted to uphold it. This chapter, grounded in transcript evidence and relevant case law, implores the appeals court to recognize the blatant judicial bias and systemic failures that have plagued her case. Overturning the lower court's ruling is not just about Kelli Lynch. It is about sending a powerful message that pro se pleas for justice cannot be ignored, and that due process must be more than a hollow promise for all. Chapter 7, A Calculated Campaign of Intimidation. Judge Madrigal's Assault on Due Process and Free Speech. This chapter unveils a disturbing pattern of judicial misconduct orchestrated by Judge Diego Madrigal III, targeting Rusty Miller, an associate of Ms. Lynch. This chapter delves into the chilling reality of a judge abusing his power, not merely through negligence but through a deliberate and calculated campaign of defamation and intimidation, silencing potential witnesses and isolating Ms. Lynch from her support system. This behavior constitutes a blatant disregard for ethical conduct, a potential violation of Florida law, and a direct assault on the principles of fairness and due process. A calculated campaign of character assassination. During a February 2024 hearing, Judge Madrigal launched into a tirade against Mr. Miller, falsely accusing him of practicing law without a license and attempting to influence Ms. Lynch's legal decisions. These accusations, based on unsubstantiated claims, were leveled despite the state attorney confirming that Mr. Miller had not filed any motions on Ms. Lynch's behalf. This blatant disregard for judicial impartiality is evident in the judge's repeated, public attacks on Mr. Miller, revealing his intent to intimidate and silence a potential witness. Transcript evidence. Judge Madrigal. It has become very apparent to me that this guy named Rusty was filing motions into the case on your behalf, and he signed his name to them, which is a crime. State Attorney Walsh. I don't believe he filed them. Judge Madrigal. Because of Rusty's advice, you believe it's a good idea to withdraw your plea. Unlawful disclosure of sealed records. Compounding the injustice, Judge Madrigal publicly disclosed Mr. Miller's sealed criminal history, a blatant violation of his legal right to privacy. This deliberate act not only constitutes a serious breach of judicial ethics, but potentially violates Florida Statute Section 943.059, which restricts the release of sealed criminal history information. The judge's actions directly contradict the intent of this statute, which aims to protect individuals who have successfully completed a sealing or expungement process from the stigma and prejudice associated with past offenses. Transcript evidence. Judge Madrigal. Is it Rusty Christopher Miller? A guy who has had grand theft, defrauding an innkeeper, grand theft, possession of a controlled substance, defrauding an innkeeper, trafficking, a warrant in Georgia, reckless driving, DUI. Is this the guy we are talking about? A chilling effect on free speech. The judge's relentless attacks on Mr. Miller appear to stem from a desire to suppress dissent and protect the court's image. By portraying Mr. Miller as a criminal influence, Judge Madrigal aimed to discredit Ms. Lynch's support network and intimidate anyone who might question the court's actions. This strategy created a chilling effect on potential witnesses and advocates for Ms. Lynch, effectively discouraging them from speaking out or challenging the court's narrative. Transcript evidence. Judge Madrigal. She was already supposed to be in DOC, Department of Corrections, if it were not for her buddy Rusty. Denial of due process and abuse of power. Judge Madrigal's actions towards Mr. Miller represent a clear abuse of judicial power and a violation of due process. Mr. Miller, who was not a defendant in the case, was denied the opportunity to defend himself against the false accusations leveled against him. This denial of basic fairness, coupled with the unlawful disclosure of his sealed records, underscores a troubling pattern of judicial misconduct and a systemic failure to protect the rights of individuals who dare to challenge the court's authority. Relevant case law and legal ramifications. While judges are typically granted immunity for actions taken within their judicial capacity, this immunity does not extend to non-judicial acts or actions taken outside their jurisdiction. In the case of Bradley v. Fisher, 80 U.S. 13 Wall. 335 1871, the Supreme Court held that a judge's actions are only protected by immunity if they are judicial acts, meaning actions that are normally performed by a judge and are within the scope of his court's jurisdiction. Judge Madrigal's public defamation and disclosure of sealed records, particularly considering Mr. Miller was not a party to the case, could be considered non-judicial acts, potentially exposing him to legal liability. Furthermore, Florida Statute Section 760.37 makes it unlawful to coerce, intimidate, threaten, or interfere with any person exercising their legal rights. The judge's behavior towards Mr. Miller, particularly his attempt to intimidate him into silence and discourage him from supporting Ms. Lynch, could be construed as a violation of this statute. Conclusion. The evidence presented in this chapter paints a disturbing picture of judicial misconduct and abuse of power. Judge Madrigal's actions towards Mr. Miller were calculated attempts to silence dissent, intimidate potential witnesses, and ensure a conviction with little regard for due process or ethical conduct. These actions, if left unchecked, not only undermine the integrity of the judicial system, but also erode public trust in the very institutions designed to uphold justice and fairness. The appeals court has a duty to address these egregious breaches of conduct and ensure that such behavior is met with appropriate accountability. The following is the complete transcript of this day. Let us use the example in this transcript of how a hearing in the state of Florida should never be conducted and further proof of no limits that this court has behaved themselves when their plans do not occur the way they choose them to occur. This is a court gone mad.
Kelli Lynch, 2022 CF 688A state.
Richard Walsh to the floor.
Okay.
You guys not apologize, I was in, I just
Now please raise your right hand to be sworn.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. So, Schwartz, I don't know if you're caught up on this case or not. There is a executed plea form from June 23rd when she came for her sentencing the first time. Ms. Lynch said this hadn't been explained to her. I played the audio from my plea colloquy for her, where she said it had been explained to her. She subsequently a conflict developed between her and Mr. Mills. He withdrew from the case. She had filed a pro se motion to withdraw her plea, which was stricken. More concerningly to me, who the heck is Rusty?
He's here somewhere.
Who is Rusty? I'm asking you.
Who is he? He's my best friend. He's helping me.
So it became fairly apparent to me that a character named Rusty Miller was filing motions on your behalf in the court file, which is a crime to give legal advice without having a proper license is a crime, and he did the state the favor of signing them and putting his name on them. I don't know if the state's going to pursue charges against him, but that's between them and...
I'm aware of the situation. I don't think he filed them. I think he prepared them.
Well, preparing...
Right, I'm just...
And it was fairly clear that he was giving legal advice because he filed text messages that he had exchanged. I'm very concerned with this. If Rusty's here, I will tell him... I'm going to tell you, don't listen to Rusty. Rusty's not a lawyer. What's the maximum penalty on this case?
On this
Charge?
charge? The mandatory minimum.
No. The maximum.
The maximum?
As charged, not what you pled to.
Right, 30, 60, 75, 80.
All right. So you face 80 years in prison, and due to Rusty's advice, you have decided it is a good idea to withdraw your plea to, was it 3 years? Is that what it was?
I believe so.
A 3-year minimum mandatory sentence and risk 80 years in prison because of Rusty, who's not a lawyer. So, Mr. Schwartz, does she want to continue withdrawing her plea?
I'm asking the court to allow to give us a little more time to talk about it. I've spoken to Rusty, so I'm familiar with.
Where is Rusty's here? Yeah. I'd like to talk to Rusty.
But he's not the one that filed.
I'd like to talk to
few of
Rusty.
the motions, though.
He put his name. I said, "My name is Rusty Miller. I'm filing this."
Like with the plea.
I can read. You know, I can read.
Plea and stuff. That you don't put his name on that one.
I went to one president said, I went to really fancy colleges, got a really fancy education.
Yes, I understand that, Your Honor.
But because of the fact that there's been a lot of information sort of floating about in this matter, what I'm asking is I want to make sure. So I want to make sure that Ms. Lynch makes the right call in this case. So I'm asking just to continue it. I think we just got reappointed just about a week ago.
You did.
So I just want to make sure that
I'm just a little bit tired of the games being played on this case. It was a very good resolution for her. It was a very good, based on the things that were filed publicly in the court file, I believe the proffer that was described as a disaster. Described as a disaster in the plea, or maybe that's my word. Did not go well. The proffer did not go well. And so,
Judge, if I may, I've already indicated, and nothing has changed, that the state's position is whatever the defendant wants. If she wants to go to sentencing, fine. If she wants to withdraw her plea, fine. The only thing I asked for is let's not keep stalling this off. I have victims, real people who want to get this resolved. It'll be next year at the earliest.
We have, this plea was entered in June. We're at 6 months. 6 months from a plea for a sentence. It's absurd. It's absurd. And this knucklehead named Rusty, who's giving you Lord knows what advice, he's not a lawyer. He's not going to be sitting in jail with you when you might be doing 80 years. You understand that? He's going to be at home, probably forgetting, don't talk to me until I say you can talk. He's going to be at home, sitting at home, watching football, forgetting about you. He's not going to be thinking about you. He may come visit for the first 6 months, but then he's not even going to visit you. Okay? You're going to be alone in jail because of his advice. Okay, you got 3 years. You got an amazing offer. Okay?
Can I speak?
Not yet. Okay? So, you keep bringing people with you to court. Will you look at me when I talk to you?
I'm sorry.
You keep bringing people with you to court. You always bring a whole entourage with you to court. And I see these people, they're whispering, they're talking to you back there. The only people you should be talking to are your attorney. Okay? I'm going to set this for trial right now, and we're either going to go to a plea or we're going to set it for trial. I'm done. No more continuances on your case. I'm done. I'm going to set it for trial on January 8th. On January 8th, time certain. So I'm not sending it for this trial period. Okay? The last day I will accept a negotiated plea on your case will be well, when do you want to be the last day? That we either withdraw the plea or we take it.
I, of course, have no idea what my witness's availability is for that date at this point. So I need to check on that. I would say, would it be fair to say?
I got December 14th, December 18th trial case management.
I would like to know if they want to withdraw their plea by December, 4th?
That's the third week of this trial period.
Right, but they just want time to talk about it, and if they want to come in and, so, or is the court granting the motion to withdraw? Because I'm not.
There's no motion, I don't think.
I know there's no motion to withdraw the plea at this stage, because the one that was filed was a nullity.
I think Mr. Schwartz wants time to talk to her.
Right.
I mean, you're still under the auspices of the Quarterman's Agreement if you break the law between now and then. And part of the agreement is that you will not withdraw your plea. I don't have to allow you to withdraw your plea. I mean, I understand even if the state stipulates, I don't have to go along with it. You understand that, right?
Yes.
Okay. How much time do you need to talk to Mr. Schwartz about that decision to withdraw or not withdraw your plea?
I mean, I've just got to speak with him once, I think maybe twice, really quick. So, I mean, a little bit of time to speak with him, that would be nice. I don't.
Okay. Who are you not going to talk to about your decision?
I understand. Rusty Miller.
Tell me exactly who. I want you to say it. You will not talk to Rusty Miller for any legal advice.
Correct.
Okay. I want you to hear you say that sentence.
I will not take any legal advice from Rusty Miller.
Okay.
Your Honor, I just want to make it clear for the record. I'm not being disrespectful. I'm just giving the dates to my assistant.
Oh, on your phone? Okay. Yeah. Anything further on this case?
Okay, so are we set time certain for January the 8th?
Pending any motions that may address a conflict in witness schedules.
All right. And so the court is, in fact, granting the withdrawal of the plea.
I'm not granting anything.
Okay.
They want time to talk about it, don't you? Or do you want to withdraw the plea?
So that's what I want time to talk about, Judge. So, and I'm sorry, did the court say you got to know by 12/4? Is that the date that was thrown?
That's the date I asked for.
Is that sufficient time?
I think that'll be sufficient time, Judge. Yeah.
Is it Rusty Christopher Miller?
Mm-hmm.
All right. A guy who's had charges for defrauding an innkeeper and fraud and defrauding an innkeeper and grand theft third degree and fraudulent use of credit card and defrauding an innkeeper and grand theft third degree and expired or revoked credit cards and possession of methamphetamines and having a fugitive warrant out of the state and trafficking amphetamines and illegal drugs conspired to traffic and DUIs and careless drivings. This is a guy we're talking about? This is a guy?
I wasn't aware of all of that.
Okay. All right. Okay. Is that your boyfriend?
No.
Okay. All right. All right. We'll see you guys January 8th. Or do you want to set it for the TCM?
I think that would be a good idea, Your Honor.
All right, so that TCM is December 18th, 1 week before Christmas.
December 18th?
Or Hanukkah. I don't know when Hanukkah is this year, Mr. Schwartz.
I also
what time do you want?
Whatever's good for him.
So we have TCM, so it's the all day.
So we can do, Judge, let's do 11, if that's okay.
Right.
Here. 11 o'clock.
Then the parents required.
Yes. All right.
I'll be able to talk to you tomorrow.
And I just want to make clear one thing. I'm not saying you would get 80 years. Okay, so I don't want you to think that I'm saying that's the maximum penalty. One of the things that I just would like y'all to understand is right now it's just words on a page. Right? Well, the allegations are words on a page. So, we make independent Record about words on a page. When people come in and testify, and if you're convicted, which is not a guarantee, but if you're convicted, then they have a chance to give an impact statement on how the case has impacted them. So potentially, perhaps your attorney presents evidence, I'd go below that offer after trial, maybe. But if you're convicted and once people, I can't go below the min-man though, once people testify and say how it affects them, the penalty could get worse. That's all I'm saying. So I'm not saying you'd go to, hey, if you're convicted, you're getting 80 years. I don't want you to, by any means, take this as me saying that. I will give you a fair and impartial sentence if you're convicted based on the evidence that I hear and the impact statements that may be provided after the trial. So I think it's very unlikely you would come anywhere near the maximum, to be honest with you, like anywhere close, even no matter what. But it is a possibility. So, anything else from the state?
No, Your Honor.
Anything else from defense?
Yes, sir. Thank you.
All right, we got Kelli Lynch.
Chapter 8 Brady Violations. A calculated suppression of exculpatory evidence. This chapter uncovers a blatant violation of Ms. Lynch's right to a fair trial. The state attorney's deliberate withholding of exculpatory evidence. This critical evidence, a valid prescription for the controlled substance Ms. Lynch was accused of trafficking, could have significantly weakened the prosecution's case or even led to a dismissal of charges. Instead, it was used as a bargaining chip, highlighting a calculated deception by the prosecution to secure a conviction. The exculpatory evidence. A valid prescription. The crux of the issue lies in a valid prescription for the controlled substance Ms. Lynch was charged with trafficking. This prescription, if disclosed, would have substantially challenged the premise of the trafficking charge, potentially undermining the entire case against her. Transcript evidence. Jonathan Mills, defense attorney. Well, you know she has a prescription for the trafficking charge, even if she withdraws her plea. State attorney's knowledge and deliberate deception. Court transcripts reveal that the state attorney was fully aware of this valid prescription. During a sidebar conversation, Ms. Lynch's attorney, Jonathan Mills, explicitly stated, well, you know she has a prescription for the trafficking charge, even if she withdraws her plea. This statement confirms the state attorney's knowledge of the exculpatory evidence and their decision to suppress it. Instead of disclosing this crucial information, the state attorney offered to dismiss the trafficking charge as part of a plea deal, presenting it as a benefit to Ms. Lynch. This was a manipulative tactic designed to coerce her into accepting a plea, even though the evidence could have cleared her of a major charge. Transcript evidence. A state attorney Walsh. Null pros on count 2. That's the benefit. She'd be pleading to counts 3 and 4, which carry no minimum mandatory. The Brady Rule violation. The state attorney's failure to disclose this exculpatory evidence and their manipulation of the plea bargaining process constitute a clear violation of the Brady Rule. Established in Brady v. Maryland, this rule mandates that the prosecution must disclose any evidence favorable to the accused upon request. The transcript evidence. A pattern of concealment. The state attorney's own words, recorded in the transcript, expose their deliberate actions. A state attorney Walsh. Null pros on count 2. That's the benefit. She'd be pleading to counts 3 and 4, which carry no minimum mandatory. Judge Diego Madrigal 3. And the total sentence? 3 years. A state attorney Walsh. Yes, Your Honor. That's what the state would be asking for. The score sheet itself comes in at about 14.5 months, if you were to take out the mandatory sentences. This exchange highlights the state attorney's calculated approach to use the dismissal of a charge, supported by exculpatory evidence, as leverage in the plea deal negotiations. Conclusion. A deliberate obstruction of justice. The state attorney's actions in this case go beyond mere prosecutorial zeal. They demonstrate a deliberate intent to obstruct justice by suppressing exculpatory evidence and manipulating the plea process. This blatant disregard for the Brady Rule underscores the urgent need for accountability and reform within the Ninth Judicial Circuit. The transcripts provide undeniable evidence of a calculated strategy to secure a conviction, even at the expense of truth and fairness. Chapter 9, A Web of Deception, the state's duplicitous charges and the failure of defense. This chapter exposes a deeply troubling pattern of negligence and manipulation within the State v. Lynch case, highlighting a blatant disregard for the fundamental right to a fair trial. The state's intentionally ambiguous charging document, designed to encompass both a first-degree felony and a third-degree felony, effectively undermined Ms. Lynch's ability to mount a proper defense and constitutes a clear violation of due process. This chapter uncovers the critical legal misstep and the troubling inaction of the defense, culminating in a system where the accused faces an uphill battle against a state willing to bend the rules for a swift conviction. A calculated ambiguity, the state's duplicitous strategy. The state's charging document, a crucial document outlining the charges against Ms. Lynch, was riddled with a deliberate ambiguity. Instead of clearly specifying which statute they intended to pursue, the first-degree felony under 817.568 (c) with its strict requirements for monetary benefit or victim count, or the third-degree felony under 817.568 with its broader definition of fraudulent use, the state chose to weave language from both statutes together, creating a confusing and potentially misleading picture. This deliberate obfuscation directly contravenes the principles of due process, which demand clarity and fairness in the charges leveled against the accused. Exhibit A. The charging document's flawed language. The state's charging document, instead of clearly stating the applicable statute and its elements, presented a confusing blend of both first-degree and third-degree felony language. This ambiguity served a strategic purpose: to leave Ms. Lynch and her legal team uncertain about the specific crime they were defending against. This tactic, designed to create confusion and advantage for the prosecution, directly contradicts the principles of due process, which demand that the accused have clear and unambiguous knowledge of the charges they face. Exhibit B. The charging affidavit's lack of specificity. Further compounding the problem, the charging affidavit, meant to lay out the factual basis for the charges, failed to provide concrete evidence that Ms. Lynch met the strict requirements of the first-degree felony. The affidavit, in essence, acknowledged that the attempt to purchase a vehicle with a fraudulent ID was not successful, implying a lack of evidence to support the claim of pecuniary benefit exceeding $50,000 or fraudulent use of 20 or more identities. This lack of specificity further reinforces the impression that the state was pursuing a broader third-degree felony charge under 817.568 (a), but deliberately using the language of the more serious first-degree felony. The failure of the defense, a missed opportunity. Despite the glaring inconsistencies and ambiguities in the charging documents, Ms. Lynch's defense team, with the exception of Ms. Kazi, failed to effectively challenge the state's tactics. While Ms. Kazi, in a demonstrably responsible act, drafted a motion to dismiss based on the state's mischaracterization of the law, this motion was never filed. The reasons for this failure remain unclear, yet raise concerning questions about the defense's commitment to Ms. Lynch's rights. Was it intimidation, pressure to protect the court's image, or a fundamental misunderstanding of the law? Regardless of the reason, the missed opportunity to challenge the state's duplicitous tactics had a devastating impact on Ms. Lynch's case, leaving her vulnerable to a conviction based on an intentionally ambiguous charge. The implications of inaction, a system in crisis. The state's deliberate ambiguity in the charging documents, coupled with the failure of the defense to challenge this tactic, speaks volumes about the systemic challenges within the justice system. The state's willingness to leverage misleading language to secure a conviction, and the defense's inability to respond effectively, highlight a system where the accused is often at a distinct disadvantage. This scenario underscores the urgent need for reform, emphasizing the critical importance of providing competent and vigorous legal representation to those accused of crimes. The grave consequences of waiting, a trial's uncertain outcome. Ms. Lynch's current attorney's insistence on challenging the charging document only at trial presents a dangerous and misguided strategy. While waiting until trial could potentially lead to the dismissal of the charge, the risk of conviction on lesser charges remains significant. This is particularly alarming considering the judge's alleged bias, which suggests a heightened risk of a conviction regardless of the evidence. Further, waiting until trial would preclude any opportunity to address the state's duplicitous strategy through pretrial motions, leaving Ms. Lynch vulnerable to a conviction based on an ambiguous and potentially misleading charge. Florida law and the need for pretrial intervention. Florida law clearly recognizes the importance of addressing defective charges at the pretrial stage. For instance, Rule 3.190F, one of the Florida Rules of Criminal Procedure, allows for a motion to dismiss an indictment or information based on defects in the charging document, including vagueness and ambiguity. Waiting until trial to raise these issues would severely limit Ms. Lynch's ability to challenge the state's misconduct, and would essentially force her to proceed under a cloud of uncertainty regarding the specific charges she faces. The attorney's dereliction of duty, a breach of trust. The actions of Ms. Lynch's attorneys, with the exception of Ms. Kazi, represent a severe failure of legal representation. Their failure to challenge the state's duplicitous tactics, despite their obvious legal shortcomings, and their insistence on waiting until trial to address the issues, demonstrate a clear disregard for Ms. Lynch's rights and a troubling lack of competence. Their actions raise serious questions about their motivations and commitment to their client's defense. This case underscores the urgent need for greater scrutiny of legal representation in criminal cases, particularly when facing a state willing to engage in questionable tactics. Chapter conclusion. A call for accountability and reform. Ms. Lynch's case serves as a stark reminder of the potential for manipulation and abuse within the justice system. The state's deliberate use of ambiguous language, coupled with the defense's inaction, created an unfair playing field, jeopardizing Ms. Lynch's right to a fair trial. This chapter, grounded in legal analysis and transcript evidence, implores the appeals court to recognize the egregious violations of due process and the systemic flaws that have impacted Ms. Lynch's case. Overturning the lower court's decision is not only a matter of justice for Ms. Lynch, but also a crucial step toward ensuring a fairer and more transparent system for all. This court must recognize the perilous situation Ms. Lynch faces, the shortcomings of her legal representation, and intervene to ensure that the justice system upholds its sworn obligation to protect individual rights and ensure a fair and impartial trial for all. Failure to do so would set a dangerous precedent and perpetuate a system where the accused is vulnerable to manipulation and injustice. Chapter 10, The Paper Trail of Deception, a case built on flawed evidence and coercion. This chapter delves into the heart of the State versus Lynch case, exposing a disturbing pattern of evidence manipulation and a blatant disregard for due process. The physical evidence, the cornerstone of any criminal prosecution, unravels as a web of deceit, leaving the state's case hanging precariously by a thread. This chapter unravels the alarming reality of a case built on unreliable evidence and fueled by an unrelenting pressure on Ms. Lynch to accept a plea deal, even without a legitimate case. The physical evidence, a house of cards. The foundation of the state's case rests on the physical evidence, the Texas ID allegedly presented by Ms. Lynch during the attempted vehicle purchase. However, this evidence quickly crumbles under scrutiny. The police report states that the ID was furnished by Scott McAlpine, the dealership's general manager, not found on Ms. Lynch. This raises immediate concerns about potential evidence tampering and raises significant questions about the chain of custody. The report also highlights the fact that Ms. Lynch was leaving the dealership, attempting to abandon the transaction. This act, clearly demonstrated by the officer's report, should significantly mitigate her culpability, if not entirely absolve her of any wrongdoing. The abandonment defense, outlined in Section 777.045 of the Florida statutes, states that a defendant who voluntarily and completely renounces their criminal purpose before the crime is completed, and without knowledge of impending law enforcement intervention, may not be held criminally liable. Ms. Lynch's actions, as documented in the police report, clearly demonstrate an attempt to withdraw from the alleged crime. Adding to the troubling nature of the evidence, the report further reveals that two key witnesses, critical to corroborating the state's narrative, are unavailable. One has since passed away, and the other has gone missing, raising suspicions about potential witness intimidation and evidence suppression. The missing pieces, a case built on missing witnesses and manipulated evidence. The state's case relies heavily on the testimony of Scott McAlpine, the only remaining witness to the alleged crime. This reliance on a single witness with potential biases further weakens the state's argument, particularly considering the critical absence of other corroborating evidence. Furthermore, the crucial documentation related to the attempted vehicle purchase was certified to a Louise Holt, not Ms. Lynch. This glaring error, discovered during a motion to suppress evidence filed over 2 years ago, casts a shadow of doubt over the entire case. The motion, readily available for public view, demonstrates a fundamental flaw in the state's evidence, calling into question the legitimacy of the charges against Ms. Lynch. The state's unwavering determination to secure a conviction. The state's response to this critical evidence discrepancy is telling. Despite the glaring error in the documentation and the questionable reliability of its key witness, the state has actively resisted any attempt to rectify the issue. Instead, the state has chosen to pressure Ms. Lynch into accepting a plea deal, seemingly willing to circumvent due process for the sake of a quick resolution. The transcript excerpt, where the state attorney justifies his inability to secure a deposition of Scott McAlpine, further underscores this alarming trend. Mr. Scott McAlpine. Mr. McAlpine is in Europe now and will be for several months. State could proceed without him. But as far as the deposition going, I can try to schedule that Zoom, but I can't guarantee that. And I don't want that to be grounds for a further continuance, because we can't get a hold of him now that he's in Europe. Judge Diego Madrigal 3. Okay. My understanding is that Europe has the internet. State Attorney Richard Walsh. It is true. But it's not It's also my understanding that I'm going to compel somebody in Europe and... This exchange highlights the state's willingness to ignore the obvious shortcomings of its evidence and proceed with a flawed case, relying on the court's complicity and Ms. Lynch's vulnerability to secure a conviction. Case law and the right to a fair trial. This chapter draws attention to the critical legal principles that have been violated in Ms. Lynch's case. A Brady v. Maryland 373 U.S. 83, 1963. This case mandates that the prosecution must disclose any evidence that is favorable to the defendant, regardless of whether it is exculpatory or impeachment material. The state's failure to address the discrepancies in the evidence and the potential bias of its key witness, along with the withholding of crucial information about the missing witnesses, constitutes a violation of the Brady Rule. United States v. Agers 427 U.S. 97, 1976. This case further clarified the Brady Rule, stating that the state has a duty to disclose evidence that is material to the guilt or innocence of the accused. The flawed documentation and the questionable evidence in Ms. Lynch's case fall under this category, demanding immediate action by the state to rectify the situation. Agiglio v. United States, 405 U.S. 333, 1972. This case expanded the Brady Rule, including evidence that could be used to impeach a witness. The state's reliance on the sole testimony of Scott McAlpine, a witness with potential biases, while withholding crucial information about the other witnesses, constitutes a violation of the Giglio Rule. A Florida Rules of Criminal Procedure 3.190F. When this rule allows for a motion to dismiss an indictment or information based on defects in the charging document, including vagueness and ambiguity. The state's deliberately vague charging document, designed to obscure the specific charges against Ms. Lynch, should have been challenged by her legal team during pretrial motions. This failure to act, combined with the state's refusal to clarify the charges and address the flawed evidence, constitutes a clear violation of Florida law. A Strickland v. Washington 466 U.S. 668, 1984. This landmark case established the two-pronged test for ineffective assistance of counsel. The actions of Ms. Lynch's attorneys, with the exception of Ms. Kazi, demonstrably fall below this standard, highlighting a critical failure of the system to provide Ms. Lynch with effective legal representation. Their failure to challenge the state's duplicitous tactics, and their unwillingness to aggressively defend Ms. Lynch's rights represent a clear breach of their ethical obligations. Conclusion: the urgency of appellate intervention. This chapter underscores the need for immediate and decisive action from the appeals court. The evidence presented, coupled with the state's questionable tactics and the defense's failure to challenge these actions, paint a disturbing picture of a system that is actively working against Ms. Lynch. The appeals court must intervene to rectify these injustices, overturn the lower court's flawed proceedings, and protect Ms. Lynch's right to a fair trial. This case stands as a stark reminder of the vulnerability of the accused, when faced with a system that prioritizes expedience and control over justice and due process. The appeals court's decision will not only impact Ms. Lynch's future, but also determine the future of the justice system itself. Chapter 11, A Portrait of Bias. Unmasking the orchestrated campaign against Ms. Lynch. This chapter unveils a deeply troubling portrait of judicial bias, showcasing a pattern of behavior that goes beyond mere negligence. Judge Madrigal III in this chapter demonstrates a calculated campaign against Ms. Lynch, silencing potential witnesses, undermining her legal representation, and effectively isolating her from her support system. This chapter will delve into the transcript, showcasing the judge's relentless attacks on Rusty Miller, his manipulation of the legal process, and his chilling attempts to control Ms. Lynch's legal decisions. The judge's intimidation and defamation of Rusty Miller. The transcript reveals a chilling pattern of the judge attacking Mr. Miller, labeling him as a criminal influence on Ms. Lynch, and accusing him of practicing law without a license. Despite the state attorney confirming that Mr. Miller never filed any motions on Ms. Lynch's behalf, the judge continues to make these accusations, publicly discrediting Mr. Miller in the courtroom. Judge Madrigal: it has become very apparent to me that this guy named Rusty was filing motions into the case on your behalf, and he signed his name to them, which is a crime. To impart to give legal advice without having a proper license is a crime. And he did the state the favor of signing them and putting his name on them. I don't know if the state's going to pursue charges against him, but that's between them and State Attorney Walsh. I'm aware of the situation. I don't think he filed them. Judge Madrigal: because of Rusty's advice, you believe it's a good idea to withdraw your plea. Judge Madrigal: she was already supposed to be in DOC, Department of Corrections, if it were not for her buddy Rusty. Judge Madrigal: she had not changed her mind, but Rusty, her buddy Rusty, does lawyer filings up in my court file. Judge Madrigal: he's filing motions on this case. Judge Madrigal: all right. Is it Rusty Christopher Miller? All right. A guy who's had charges for defrauding an innkeeper and fraud and defrauding an innkeeper and grand theft, third degree and fraudulent use of credit card and defrauding an innkeeper and grand theft, third degree and expired or revoked credit cards and possession of methamphetamines, and having a fugitive warrant out of the state. And trafficking amphetamines and illegal drugs, conspired to traffic, and DUIs and careless driving. This is a guy we're talking about. This is a boyfriend. The judge's relentless accusations against Mr. Miller, despite the lack of evidence, are clearly intended to intimidate him, to discourage him from supporting Ms. Lynch, and to create a chilling effect on anyone else who might challenge the court's narrative. This behavior is a direct violation of judicial ethics, a potential violation of Florida Statute Section 943.059, regarding sealed criminal history records, and a clear assault on the principles of due process and free speech. The judge's attempts to control Ms. Lynch's legal decisions. The judge's bias extends beyond Mr. Miller. Throughout the transcript, Judge Madrigal exhibits a clear attempt to steer Ms. Lynch's legal decisions. He warns Ms. Lynch against seeking legal advice from Mr. Miller, demanding that she explicitly state she will not take any legal advice from him. Judge Madrigal: tell me, exactly who? You say you will not talk to Rusty Miller for any legal advice. Judge Madrigal: I want you to hear you say that sentence. Kelli Lynch: I will not take any legal advice from Mr. Miller. The judge's attempts to control Ms. Lynch's legal decisions extend beyond her interactions with Mr. Miller. He directs her to stop bringing support people to court, accusing them of whispering and talking to her, telling her the only person she should be talking to is her attorney. Judge Madrigal: you keep bringing people with you to court. You always bring a whole entourage with you to court. And I see these people, they're whispering, they're talking to you back. They're the only people you should be talking to are your attorney. Okay. The judge's behavior, evident in these interactions, reveals a deeply disturbing attempt to isolate Ms. Lynch from her support system and to control her legal choices. This blatant interference with her autonomy further undermines the principle of due process and raises serious concerns about the judge's ability to preside over the case fairly. The judge's dismissal of Ms. Lynch's pro se motions. This chapter also highlights the judge's dismissive treatment of Ms. Lynch's pro se motions, intended to address the shortcomings of her appointed attorney, Jonathan Mills. The judge immediately dismissed these motions as legal nullities, ignoring their content, and failing to recognize her explicit objection to Mr. Mills' withdrawal. Judge Madrigal: the document that I was handed is somewhat contradictory. It is a request for a new attorney and objection to a withdrawal, which seem to be contradictory. Judge Madrigal: and that's somewhat of what? One of the things I wanted to discuss with you all at the bench, but we'll just discuss it in the open. So they're filed pro se. Once you have an attorney, the attorney can file things on your behalf. Mr. Mills does have a motion to withdraw set on the case. And my concern, and I guess let me ask Mr. Lynch, do you want an attorney, or do you want to represent yourself? Kelli Lynch. I would like an attorney, please. Judge Madrigal. So the logistical issue that would come up is, Mr. Mills has indicated a conflict. If that motion is well taken, which I anticipate it will be granted. She's requesting an attorney. I don't think we can proceed on anything else, including the motion to withdraw plea or sentencing, because she's requesting an attorney. And there's no attorney here to represent her on those pending motions. I think we have to address the withdrawal first because of the conflict to help. Judge Madrigal. Okay, but there's no motion filed, so you're going to have to talk to them about refiling the motion. Okay, Mr. Walsh has indicated if the motion is refiled, he's not going to oppose me granting that motion. All right, now there's no motion, so I'm not going to sentence you because you don't have an attorney here today. The judge's behavior in this instance showcases a clear bias towards expediency and a disregard for Ms. Lynch's right to be heard. His dismissive treatment of her pro-se motions, coupled with his failure to recognize her objection to Mr. Mills's withdrawal, effectively silenced her voice, further isolating her from a fair trial. Conclusion: a system in crisis. The transcript evidence presented in this chapter reveals a disturbing picture of a system failing to protect the vulnerable. Judge Madrigal III's actions, seemingly driven by a desire to protect his own image and to expedite the case, have seriously compromised Ms. Lynch's right to a fair trial. His constant attacks on Mr. Miller, his attempt to control Ms. Lynch's legal choices, and his disregard for her pro-se motions highlight a system that is not designed to serve justice but to protect those in power. The appeals court must act decisively to address this miscarriage of justice. Failing to dismiss the case with prejudice based on the judge for the actions in this case would not only perpetuate a grave injustice, but also set a dangerous precedent, further eroding the promise of a fair and impartial justice system for all. Conclusion: a plea for justice and a system in need of repair. The State v. Lynch case lays bare a deeply troubling reality within our justice system: the erosion of fundamental fairness in the pursuit of expediency and control. This report has meticulously documented the systematic violation of Ms. Lynch's rights, exposed a calculated campaign of bias orchestrated by Judge Madrigal III, and unveiled a web of deception woven by the state's attorneys. From the fabricated Quarterman agreement, to the judge's silencing of potential witnesses and Ms. Lynch's own attempts to navigate her legal challenges, the proceedings in the lower court have been a travesty of justice. Each chapter of this report has presented compelling evidence demonstrating a clear pattern of judicial misconduct, negligence by defense counsel, and a state willing to bend the rules for a quick conviction. The appeals court now faces a pivotal moment. Failure to intervene in this case will send a chilling message that due process, the bedrock of our legal system, is a hollow promise for those who lack power and resources. The systemic failures documented here are not isolated incidents but indicative of a deeper crisis within our courts, a crisis that demands urgent attention and swift action. The appeals court's duty to act, a clear path to dismissal. The evidence presented in this report, grounded in transcript evidence and relevant case law, provides the appeals court with a compelling argument to overturn the lower court's rulings and dismiss the case with prejudice. Several key legal precedents provide the necessary grounds for such action. Each on their own gives a reason to dismiss with prejudice, however in totality, it becomes the only option for such misconduct. A due process, Boykin v. Alabama, the blatant disregard for Ms. Lynch's right to understand the charges and the consequences of her plea, the coerced nature of the Quarterman agreement, and the manipulation of the legal process have all violated her fundamental right to due process. The appeals court can invoke Boykin v. Alabama to ensure that pleas are knowing, intelligent, and voluntary, voiding the plea entered by Ms. Lynch. A effective assistance of counsel, Strickland v. Washington, the incompetence and failure of Jonathan Mills to provide Ms. Lynch with effective representation, his blatant disregard for her interests, and his collusion with the court have all undermined her Sixth Amendment right to counsel. Strickland v. Washington establishes a clear standard for effective assistance of counsel, which has been demonstrably breached in this case. A judicial bias, Caperton v. A.T. Massey Coal Company, the evidence of Judge Madrigal's relentless attacks on Rusty Miller, his attempt to control Ms. Lynch's legal decisions, and his dismissive treatment of her pro-se motions constitutes a clear violation of judicial impartiality. Caperton v. A.T. Massey Coal Company highlights the critical need for unbiased judges, a standard demonstrably absent in this case. A Brady rule, Brady v. Maryland, United States v. Agers, Giglio v. United States, the state's failure to disclose exculpatory evidence, the dubious nature of its key witness, the suppression of evidence regarding missing witnesses, and the deliberate ambiguity of the charging document all violate the Brady rule and its subsequent clarifications. The appeals court has the authority to dismiss the case based on the state's failure to fulfill its legal obligations under the Brady rule. A Florida Rules of Criminal Procedure flaw are CRMP 3.190F. 1. The state's deliberate use of ambiguous language in the charging document, designed to obscure the specific charges against Ms. Lynch, should have been challenged pre-trial. This failure by the defense, coupled with the state's refusal to clarify the charges, represents a clear violation of Florida law. The appeals court can intervene based on this procedural violation. A call for systemic change, protecting the future of justice. Dismissing this case with prejudice is not just about ensuring justice for Ms. Lynch, it is about protecting the integrity of our justice system for all. The actions of the lower court, if left unaddressed, will send a dangerous message. That the rights of the accused are not fundamental, that due process is malleable, and that a judge's word carries more weight than the rule of law. This report is a call to action for the appeals court, a plea to intervene and restore faith in our justice system. It is a reminder that the fight for justice is not just about winning a case, but about safeguarding the very principles that make our legal system a beacon of fairness and equality. Let this case be a turning point, a catalyst for change, and a promise that the scales of justice will once again be balanced.